Mr. Shima. I will now call the case of State v. Craig 127070. Counsel, you may approach, and Ms. Patty, you may approach when you're ready.
Again, Kristen Patty, court-appointed counsel for the appellee petitioner, Joshua Craig. In a few minutes, Mr. Sigler is going to get up and tell you that I am not arguing that this court's opinion in Brosite from 7.5 years ago, the last case to address the endorsement by the prosecution of witnesses on a criminal complaint, that I'm not arguing that it's wrongly decided. And he's correct. Why would I? When in that opinion, you gave me everything that I think I need in order to convince you that the district court was well within its discretion to deny the prosecution's third motion to endorse 10 witnesses that had known for, in some cases, 1,000 days or more on the eve of trial, with seemingly the goal of kicking defense counsel off the case. To get there, though, first we have to address jurisdiction. Today marks 165 years of Kansas statehood. And in that entire time, this court has apparently only issued 2 opinions of the thousands, 2 opinions addressing the denial of a prosecution's motion to endorse. One, in 1984, Newman, was largely about the exercise of spousal privilege and whether that was correctly applied in that case, in an interlocutory appeal. But the prosecution also had attempted to appeal from the denial of a motion to endorse witnesses. And in that case, the prosecution conceded at oral argument that this court did not have jurisdiction. And this court said, in fact, that an appellate court shouldn't exercise jurisdiction over every run-of-the-mill discretionary evidentiary ruling that a trial court might issue. The other case is Hendren from 1929, and that was an appeal on a question reserved. The language that they used at the time makes it a little bit difficult to see whether that has any application. There is one opinion from the Court of Appeals, an unpublished opinion from 1996, McAlpine, but the motion to endorse was really just piggybacked on whether a fingerprint examiner, somebody who took a fingerprint card, could otherwise testify in the suppression of that. It really wasn't about the motion to endorse. So returning back to the merits, at its essence, I think what Brosite is another opinion of this court determining whether the word shall is directory or mandatory given a particular context. Admittedly, you don't use those words at all in that opinion. But in fact, that's what it is. You reaffirmed all of your prior case law, including all the things that I've cited in the brief, saying that the prosecution could basically do it at any time. And I assume that you didn't mean at any old time they want. You still, and I realize you rejected the defendant's argument in that case that it should be construed somehow as soon as practicable. But you assumed that prosecutors were following the statute, following your prior opinions on this issue, and more or less endorsing witnesses timely. And that's not what happened in this case. In Brosite, you cited Cook, and you even quoted Cook. You quoted the part of Cook that suggested that a trial judge would be justified in denying a motion to endorse if it was believed that the prosecutor was doing so to, on purpose, was failing to endorse witnesses on purpose. You cited Price in a case from 1895. You quoted it, and you quoted the part of one paragraph that talked about discretion. And then I taught in my brief, I quote the rest of part from the rest of the paragraph, which says that the trial judge should always be convinced that the motion to endorse is being done fairly. If you go back through this court's long case law, like nearly a century and a half on this issue, you've said that whether the prosecutor is acting in good faith is important. You've allowed, and in Brosite, you talked about how the discretion of the trial court is broad. And in other cases that you reaffirmed, at least by implication, because they weren't specifically mentioned in Brosite, you've said that the trial judge was able to consider all the facts and circumstances surrounding the endorsement and consider basically anything that was related to the preparation of the defendant's defense. So here we have, again, 10 witnesses, 9 of whom are actually listed in the probable cause affidavit. It comes out at preliminary hearing where defense counsel says, if you're going to call this one guy, I'm going to have to conflict out because I represent him on another case. Because the prosecutor delayed so much in filing that motion to endorse, it didn't come out until later that there was another witness that would also cost defense counsel.
I'm interested in kind of a sequential order here. Can we first talk about jurisdiction?
Sure.
And whether we have jurisdiction, given that the vehicle for you to be here is an interlocutory appeal.
Mm-hmm.
Talk to me about that when we're discussing endorsing of witnesses. Is that what is contemplated by a suppression, a dismissal? How far do we go with that in the interpretation of our jurisdiction for interlocutory appeal? And then I'm interested in your next argument, but let's start there.
I welcome it. Frankly, I kind of expected to be interrupted before now, because I know how hot you often are. Certainly, what can be brought in an interlocutory appeal is broader than just the constitutional standard, like the denial of a motion to suppress a confession or under the Fourth Amendment or something like that. Again, in Newman, it was the exercise of spousal privilege. The issue in Myers, which is the case that the prosecution had to do with 2 prior out-of-state driving DUI convictions that changed the level between misdemeanor and a felony.
Just tagging on to Justice Rosen's questions to just narrow it. Is it your position that 22-3603 governs this case?
Yeah.
Interlocutory appeals, but so I know you're citing a lot of cases, but those cases are, what we start with is a statute, right? So based on the statute, when it says, when a district judge prior to trial makes an order, quashing a moral, suppressing evidence, an appeal may be taken by the prosecution within 14 days.
Right.
Okay. So tell me how your argument fits under that statute as far as jurisdiction goes.
Right. This is not the kind of case where there's certainly any sort of an evidentiary hearing that needs to take place, that it's really like the spousal privilege, maybe, how another statute is construed and applied. This, as much as it is possible for the prosecution to control this issue and keep from having to be an interlocutory appeal, they have the power to do so.
Well, let's make it simple, maybe.
Right.
Didn't you concede before the Court of Appeals that this was an order suppressing evidence?
No, I don't think that I did. I argued that there was not jurisdiction.
Well, I understand that, but my understanding or reading of the record at least is that the defendant admitted that this was an order suppressing evidence.
No, I conceded that the term suppressing evidence has a broader meaning than the constitutional standard.
So,
But I argued that in my brief that there was no jurisdiction.
so how is this not an order suppressing evidence?
Because at least it's unlike any other case that I could find dealing with interlocutory appeals. Obviously, there are not a lot of them. At least not that
Well,
wasn't.
forget our cases.
Right.
Just how is this not an order suppressing evidence? I mean, the district court said, state, you may not present this evidence.
Because the state has the power to control whether this even becomes an issue by endorsing its witnesses.
Yeah, and doesn't that go to the merits of the court's ruling, not the subject matter of the ruling? I mean, we're only talking about jurisdiction, not the merits. Maybe the district court was right. That's your second issue, right?
Right. You know, it's I suppose I just was not able to find enough law to otherwise interpret it than what I cited in the brief. Suppressing blood test results, suppressing an out-of-court statement, whether it was covered by spousal privilege. You know, there's not a lot outside of, say, the Fourth or Fifth Amendment context. And I don't know that there is any sort of,
Well, I'll just press you a little bit.
right.
Do you think this is an order suppressing evidence or not?
No, I don't. I think that's, as I've said, I think that this was completely within the prosecution's control if they had otherwise complied with the endorsement statute, if not by the letter, at least the spirit. And they didn't do that. I am out of time.
Let me just ask you one question on the merits. I read your argument to boil down to be the discretion to grant late endorsement when it doesn't prejudice a defendant doesn't equate to a duty to do so, essentially. In other words, right? Is that essentially your argument? And the district court had discretion to deny the endorsement.
It did, and it had, as this court has said, broad discretion, considering all the facts and circumstances. And I mean, that was one of the things that was running through my head in preparation. I certainly, you know, the facts of this case make the endorsement tantamount to the district court judge rubber stamping. And I don't think that that's the message that you want to send to
But
the
do you
district
think it
judges.
is, so then we're looking for an abuse of discretion standard. And was it either an error of fact or unreasonable for the court to consider the conduct of other county attorneys in other cases?
I suppose it is not clear the extent to which that it was this assistant county attorney himself, or how wide it was the office. And he is not the county attorney and therefore technically responsible for all the supervision of the other lawyers in the office. But then again, it almost doesn't need to. The Court of Appeals termed what Judge Kuckelman said in that regard as animus. And I didn't read it that way. I read it as he's just trying, as far as those 8 remaining witnesses that don't create a conflict for defense counsel, of why it wasn't an oversight.
And there are other bases that the district court judge gave for his ruling beyond just the failures of the office. There were bases specific to this case.
Right.
And the Court of Appeals is urging a test that looks only at surprise.
Right. And I think that, first of all, I don't think I said this yet. I think that the Court of Appeals takes syllabus paragraph 4 of Brosite and kind of isolates it from the remainder of the opinion, where this court reaffirmed all of its prior case law. It didn't go into all of the other things that I talk about in the brief that the district court has been able to consider. The other thing, and I raised it more in the petition for review, is why isn't kicking defense counsel off the trial on the Friday before it's supposed to begin on Monday, and delaying a defendant's trial from, I think the judge thought maybe 5 months? Why isn't that prejudice? I'm not sure that there was a speedy trial right in this case, but in some other case there could be. And, for him to say, you've known about this for a while, and for you to come in now and on the eve of trial, kick Mr. Floyd off the case. And for all I know, Mr. Floyd may be a very formidable opponent, and the assistant county attorney wanted something else. Why isn't that prejudice? There's nothing in the record that I am aware of that the defendant and defense counsel weren't getting along. So for the assistant county attorney to come around and kick the defense attorney off the case just at the last minute, it has that fair. How's that not prejudice?
If that was a reasonable decision by the district court to decline to allow the state to endorse those 2 witnesses, does that make the district court's ruling to decline to allow the endorsement of the 8 witnesses unreasonable that the defense counsel did not object to?
It is, there's things in your prior case law about, for example, no blanket endorsements, no, which this was, no late endorsement of somebody that you were always intending to call in your case of chief. Lack of it being just an oversight.
I'm just saying,
Right.
if the defense counsel does not object to 8 witnesses being endorsed, is it unreasonable for the district court to deny that motion?
Perhaps not, and I will acknowledge that's the weaker part of my argument. But then there's still the idea of all of these, 7 of those 8 witnesses, they've known for a long time. And if the endorsement ruling statute doesn't apply in this case, then when does it apply? No further questions?
Any other questions, colleagues? Thank you, Ms. Patty.
May it please the court, on behalf of the state of Kansas, Ethan Ziff-Sigler. I guess I'll start with the issue of jurisdiction. The order denying the prosecution the motion to endorse the witnesses effectively prohibited the state from calling those 10 witnesses at trial, and functions as a suppression of, or an exclusion of, those 10 witnesses and the suppression of evidence. That is contemplated under the interlocutory appeal statute and grants this court jurisdiction so long as the suppression of that evidence substantially impairs the state's case. The state has briefed heavily how those witnesses substantially impaired the state. The exclusion of those witnesses would have substantially impaired the state's case. This court has jurisdiction over this appeal.
Is it just based on the substantial impairment language? If it had been a different witness, would you be making the same argument?
Sorry.
Maybe a witness that wasn't so critical to like the coroner and causing death.
There's two places, one or two issues. One is that it has to be justified by the statutory language because the right to appeal is statutory. So it has to involve the exclusion of witnesses. But this court has said, tangential evidence or evidence, I believe it's the Mitchell case, where it's evidence that's kind of collateral to it. It's not, doesn't substantially impair the case. The state's case does not give rise to the right to an interlocutory appeal. So
That was my.
so it has to be both, and the state is arguing both. It was the exclusion of evidence, and the excluded evidence substantially impaired the state's case.
Can you break down the substantial impairment by witness? And specifically, I'm thinking of, I think it's Richardson and Lewis, who were the two that the defense counsel actually objected to.
Yes. And
If you had the 8 other witnesses, but not Richardson and Lewis, how would that impact the substantial impairment analysis?
I believe the substantial impairment analysis would still apply to Rison. I don't know if it's Richardson or Rison and Lewis. Rison identifies the car as belonging to one of the other individuals identified as shooting. So it provides independent analysis or independent witness verification of the vehicle, and which connects it to that. And Lewis heard a confession from the defendant that he was the shooter. So the rule on substantial impairment is not that you can't make your case at all without these witnesses, but that the witnesses provide evidence. And the Court of Appeals even cites that confessions, even though those confessions just bolster evidence, excluding those confessions is a substantial impairment to the state's case. So on the issue of jurisdiction, I believe for all 10 witnesses, the exclusion of those witnesses substantially impaired the state's case. I've briefed all 10 of those witnesses individually in my brief to the Court of Appeals. So that my arguments are there. As to the merits, and I think this is where the issue of Rison and Lewis is more important, obviously, is for 8 of the witnesses, there is absolutely no analysis that there was any sort of prejudice to the defendant. One, the defendant knew about all of these witnesses. These witnesses were all provided in pretrial discovery, in fact, pre-preliminary hearing discovery. Most of the witnesses were endorsed for, or not endorsed, were subpoenaed for the preliminary hearing. The coroner's report was admitted as an exhibit at the preliminary hearing. There is no argument whatsoever that there was unfair surprise in this case. The defendant.
I guess I'd push back on that, because all of us who have tried cases knows that the case narrows as you get closer to trial. And so the fact that you don't let the other side know what your case is about because you didn't endorse these witnesses for the trial purposes means that the defense moves over to prepare for other things. So I don't think it's enough to just say the defendant knew, what would be aware that these people are out there. But I think you start, when you don't endorse your witnesses in a timely manner, which is what trial judges are supposed to be looking at, you've focused your case, and they're entitled to prepare based on that focus. So what else do you have, I guess, that would say that the defendant wouldn't be prejudiced, other than the fact that these folks were on a list that could have been called or were called at a preliminary hearing?
Well, one, the defense never said that they were surprised or that they weren't prepared on those 8 witnesses. That was never one of their arguments. The only argument about prejudice was that the 2 witnesses that Mr. Floyd had previously represented, and I believe family court issues, would require him to withdraw from the case. the remaining eight witnesses, there was no argument that they were prejudiced. And I would say that when a witness is called for a preliminary hearing, you are talking about giving someone notice of exactly what their testimony is going to be and how you plan to use them in the preparation of your case. And I think subpoenaing witnesses, which were done in a very timely manner in this case, gives you notice that the state intends to call these witnesses.
What I don't understand is, at the preliminary hearing, this whole thing was brought up. And then the state withdrew, right? And said, okay, we're not gonna have him testify.
Lewis, yes.
Right. And so, I mean, that's to say, well, we know, we want to be able to keep defense counsel on this case. So we're going to withdraw that witness. And then, right before trial to say, oh, okay, now we're going to use him. When you know already that the defense counsel is going to have to withdraw. I mean, so to say they were on notice and they weren't surprised. Okay, I guess there would be surprise because if common sense says, oh, the state knows there's a conflict, the state doesn't, object to, wants to keep the defense counsel on the case. And so you withdrew it for purposes of the preliminary hearing. It's kind of like bait and switch.
I would disagree with that reading of the record. And obviously I wasn't there. I don't work in Leavenworth. My reading of the record was that they agreed to withdraw Lewis for the preliminary hearing so that the preliminary hearing wouldn't be delayed because they had other witnesses there and they didn't want to delay the preliminary hearing, which as a trial prosecutor, I can totally understand because you have a bunch of witnesses, some of whom are not going to be cooperative, and you're worried that they're going to disappear. I have them all there on a specific day. I can get them to testify, and then from that point on, I don't have to worry about confrontation.
Why would the same logic happen right before trial? We don't want to delay the trial.
And so
the preliminary hearing, and now we don't want to delay the trial.
Well, because my reading, and I think, and I'm trying to remember again from the record because I wasn't. My reading from the preliminary hearing transcript was that there was an understanding that Mr. Floyd was going to withdraw after the prelim because he knew there was a conflict.
Oh,
yeah,
if you could cite the record on that, because that's not how I understood it. So.
That is how I read it, and I can try to find that in the record, but I just didn't anticipate that coming up. I did not see it as a bait and switch. I saw it as everyone was on the same page that Floyd was going to withdraw, and that never happened. And that was what was confusing to me from reading the record, is I don't know as a defense attorney how you see that two of your clients are witnesses in the case. Even if the state never called them, I would have concerns that I had a conflict right there. I would because let's say that eight of the witnesses had been endorsed, they had just gone to trial. We would be in a post-trial world right now where the defendant would be claiming there was a conflict of interest because two people who had witnessed the case and been state at some point on the state's radar were his former clients. So we would also be talking about this as a conflict of interest. So
Isn't there some reliance on the fact that they didn't, that they pulled the witness at the preliminary hearing? We have enough evidence without this guy.
I think all of this is something that could be considered, but my problem is from the judge's ruling, I don't even think we're there yet. The judge based his decision on the fact that he was trying to send a message to the Leavenworth County County Attorney's Office that they needed to clean up their administrative process.
Was that 100% reliance on that, or were there other reasons? Like, for example, you waited I don't even remember how much time, but you waited until the Friday before. Did he also rely on that?
I view it as the judge saying, I am doing this to send a message to your office to.
But I'm saying when you look at the transcript objectively, did he cite any other reasons besides that?
He did. He cited
case-specific reasons.
Yes, he cited to the delay in the trial caused by Mr. Floyd withdrawing.
Let me ask you this. If appellate, I want to kind of back up to the threshold question. If appellate jurisdiction depends even in part on the impact of the judge's ruling on the state's case, how does the appellate court look at that? Because it seems to be putting the appellate court in some kind of a fact-finding process to determine whether it has appellate jurisdiction.
Sure.
Or is there something that has to happen at the district court level that the appellate court can rely on to understand and agree that it has appellate jurisdiction? I'm struggling with trying to figure out the impact on your case. How do I decide that? Do I just believe you when the state comes in and says, ooh, this was a bad deal? Or is there an analytical process that has to go into that? And I just don't know how to do that as an appellate judge.
Well, I would think my argument would be it would be based on whether or not there are facts in the record, either testimony that's been presented or proffers of evidence that have been
So we
put
would
before
have
the
to
court.
make factual findings based on the record that
Yeah.
would then support our exercise of appellate jurisdiction.
I believe so, yes. And I think that, but I do think it has to be in the record. So if there's evidence, if there are witnesses that they are excluding because of the late endorsement, and there's nothing in the record to suggest what those witnesses were going to testify to, I don't think that this court would necessarily be able to make those factual
Well,
determinations.
even let's assume they testified at the preliminary hearing.
Right.
Still, what does an appellate court do with that testimony? Is it just to assume that because you don't get to have that person say those things, it must impact your case?
Well,
We're not used to making factual determinations.
well, I don't necessarily, well, I would slightly push back on that. I mean, every time this court makes a constitutional harmlessness analysis, it is making factual determinations. I mean, if you are saying that something is harmless beyond a reasonable doubt, you are looking at the record and making a factual determination. So I don't view looking at that any different than I do looking at the testimony and saying, I think this testimony, the exclusion of this testimony would have prejudiced or not prejudiced, substantially impaired the state's case. It's the same type of analysis that's done in many, many cases in harmlessness.
If this fact-finding problem, which I struggled with as well, is a real problem, is it one of our own making?
I mean,
the substantial impairment rule is court-made, correct?
yes,
It's not in the statute.
correct.
Okay.
On the interlocutory appeal.
Right, on
Yeah,
jurisdiction.
sorry. Yes, but this is always a problem with not a problem. This is a conundrum faced by the court frequently when you say we are going to engage in harmlessness analysis. You are making fact finding about witnesses, and frequently what we find in different courts is they say, well, the evidence couldn't be overwhelming because it's a he said, she said, but none of us have seen the testimony. The two witnesses could have been completely different on the stand. The court could take efforts to require the district court to provide hearings in which they have viewed the evidence and say, well, I have seen the evidence, and as the person, I am saying that this is harmless, but this court hasn't as of yet done that in any case. The court has always looked at the record and said, we will make factual determinations in these cases.
Can I ask you a question about the scope of a district court judge's discretion under the statute and our case law interpreting and applying that? And it seems to me, at least one could argue, that the district court judge has discretion to grant a later endorsement in the absence of prejudice. But that doesn't necessarily mean the district court has to. Would you agree the district court judge still retains discretion to deny it in the absence of prejudice, so long as that ruling is not based on a factual or legal error or objectively unreasonable?
I do not. And
why is that?
Because in the law, we generally find that The goal of the trial process is to uncover the truth. And it is generally found that the suppression or exclusion of evidence is a last case scenario only used in extreme circumstances. There can be violations of the Constitution that do not result in exclusion because we find that exclusion should be a last resort reserved for specific circumstances. The good faith exception applies because of that. A reasonable mistake of fact or a reasonable mistake of law apply because of that. The reason
Wouldn't
to
that just be an
require
argument as to why the ruling's objectively unreasonable as opposed to the scope of discretion? I understand your policy argument, but is there a statutory basis where you see that limitation on the district court's discretion under 223201?
No, but I also don't see anything in the statute that authorizes a court to exclude evidence in that statute.
Well,
But-
it's the timing language in the statute, right?
But there's no remedial clause in the statute. The statute doesn't say a violation of this statute results in the exclusion of evidence. So we would have to look beyond the statute to our general principles of when do we exclude evidence from a trial. We only exclude evidence from a trial in extreme circumstances generally related to the violation of a fundamental right, because otherwise our goal is that the truth come out in trial. And the exclusion of witnesses results in an untrue trial, a trial in which context is missing. And sometimes that's justified. If there's been violations of fundamental rights, absolutely it's justified. But nothing in the statute provides a remedy, so we would look beyond the statute to what are our general rules about the exclusion of evidence? Well, our general rules about the exclusion of evidence is that it should be rare, it should be only.
Are you saying that the state should still be able to call witnesses that have never been endorsed?
If there's no prejudice at all, yes. I mean, that's why,
What's the point of the endorsement rule?
I mean, I think of the endorsement rule as mostly a prophylactic. If I give you notice in writing, in the information, you cannot later say, I'm surprised you're calling that witness. But it also doesn't, and the statute doesn't actually provide a methodology for endorsing other than that. So why is me providing you with a list of every single person involved in the case not providing you notice? The statute doesn't say anything other than it has to be done in a time and
So
manner.
there's no
prescribed.
statute that says state cannot call an unendorsed witness at trial.
I looked for one and did not find it. I'm not going to categorically say there isn't because that's how you end up having the court say there is. But I did not find something that says.
I mean, if you lose this case, are you going to go back and take it to trial and call these witnesses anyway? I mean, I know you probably can't answer that, but hypothetically, is that?
I can't make that call on their
And
behalf.
if that's true, doesn't that mean we have no jurisdiction?
No,
because
that's not true. The
Well,
substantial
either
imperative.
the evidence is suppressed because of the refusal to permit endorsement,
Oh,
or refusal to permit endorsement does not preclude the state from still calling the witnesses. And you're arguing both things.
no, okay, now I understand. I was confused. You're saying that if it went back and they did use these witnesses, well, I guess, so assuming that this court ordered nothing, it just said we're just remanding with no orders, and the district court, the district court excluded these witnesses. That is, I think that is conceded. So these witnesses have been excluded from testimony. And that has substantially impaired the state's case.
Well, strictly speaking, all the district court did refuse the state's motion to endorse the witnesses.
Yes. I wish the record were cleaner, but then within the context of what the district court says next, it's clear that the district court is saying, I'm not going to allow you to call these witnesses. And that is not challenged. No one has said that the state was permitted to call these witnesses, so.
Question.
Yeah.
Do you have an idea of whether the defendant's constitutional speedy trial rights were implicated here? As a matter of fact, I don't see it in the record.
I don't remember, and I don't remember off the top of my head. No, I think this is a question that if the court were going to remand needs to be answered, because if we know for certain that on an interlocutory appeal, if the court says we did not have jurisdiction, the speedy trial timer never stopped. If this court never had jurisdiction, but I think it's somewhat more open if the court denies the interlocutory appeal, but finds that they had jurisdiction, what happens then?
I mean, for the district court's conclusion as one basis for denying the motion to endorse. The record shows that he found the defendant's speedy trial rights to be implicated, and that was the prejudice. I'm just asking, do you know if that's actually the case? Like, would an extension of 5 or 6 months or whatever the district court thought it would be?
I'm guessing yes, just based on timing. If the defendant never waived his right to speedy trial and he wasn't going to agree to a continuance, then 180 days usually would have elapsed in that period of time.
Thank you.
And would that be the kind of constitutional taint that would be the exception to the policy rule that you gave in response to my question earlier?
I don't think there's been a specific case that has found that a defense attorney having a conflict of interest requiring them to leave the case would trigger that. And even so, that would apply to 2 of the 8 witnesses. It wouldn't, or 2 of the 10 witnesses. It would not apply to the remaining 8.
I'm curious what your position is on this. And it has to do with the discretion of the trial court judge, whom it seems that there was frustration with this particular, I think, county attorney who's representing cases before him or her. What is a trial court judge supposed to do when, in this instance, the perception is that in case after case, in spite of warnings, in spite of, the practice is late endorsement of witnesses, even though been told over and over again. And I appreciate it. It appeared to have spilled over into this case. It seems that from the record. What's the trial? Why isn't a consequence what happened here? So I've told you this 20 times. You continue this practice, and I'm not going to grant it anymore. And if that is wrong, is it a referral to the disciplinary administrator? What is supposed to happen in this instance?
I mean, in
these circumstances, let's say that's the scenario.
Yeah. So I think their referral to the disciplinary commission is obviously, like, if you believe that this is a practice that shows that you are failing to live up to the requirements of the Kansas rules of professional conduct, you should be making that referral, because if it's happening again and again and again, implicates negligence in practice, all of that. Yes, I think that's absolutely. In my own practice as a prosecutor, I had in Wyandotte judges order sanctions against the state where we were required to pay legal fees for delays caused by clerical errors that kept happening. That seemed very reasonable to me. The issue I have with the exclusion of evidence is what I went back to before. Trials are supposed to bring out the facts. They're supposed to bring out the truth. And the exclusion of evidence will always result in less context and less truth being found. And it should only be done in extreme circumstances. There are other alternatives that could have been explored here and maybe should have been, but not the exclusion of evidence.
I want to get back to Justice Deagle's line of questioning. Is the state really without a remedy here going forward in trial? I mean, you weren't allowed to endorse a witness. I don't have any in front of me, but there's, we have had lots of cases where the state shows up with a witness during trial, and then there's a discussion about whether they get to call that witness. Why don't you still have a remedy for any of the witnesses that you wanted to endorse at the last minute, still have the ability to bring them in during trial by making, again, I can't remember the law, but whatever the showing is that's required mid-trial to bring in a witness that you hadn't previously endorsed?
Generally in those cases, I think it's only brought out when there is some change in testimony. Usually it's in rebuttal. A defense witness has opened the door to previously excluded testimony. So we all agree that we're not going to mention a certain incident, but then the defense's witnesses or the defendant himself brings up another incident, makes claims about it, and then the state's witness that had been previously excluded, either because the example I can come up with is like 6455. State doesn't file a 6455 claim in time. They have a 6455 witness. Judge says you are not allowed to call that. You didn't give notice as required by statute. State says, okay, we go ahead with our case. Defendant gets up, testifies about the prior 6455 evidence in their favor. State says, fine, now we want to bring our witness in to talk about it. But I don't think that would have applied in any of these with any of these witnesses, because one, these are state's case in chief witnesses, so you don't have that door opening effect that you usually have. And second, you don't have, a lot of times when a witness shows up at the last minute, it's something more akin to what I had was we find out that the defendant made a phone call to like a person and said, hey, call the witness tonight and tell him not to show up because, you know, if he shows up, I'm going down. And then we endorse the record custodian, or we bring in the record custodian during trial. But, you know, that is contemplated by the statute already. So I don't think that any of those places the court has previously found to be exclusions to that apply. And in this case, it's clear that the judge's intent was that these witnesses not be called at trial.
Then does that mean that if we were to keep the substantially impaired standard as part of our analysis, the issue would be whether the state can actually make its case in chief?
No, the standard is, I think the standard that already exists is appropriate, which is, and I will have to pull it up for my brief, but this court has outlined the standard for substantial impairment. It does not require the absolute showing that the state cannot prove its case in chief, but only that it's harmed. If there is substantial harm by the exclusion of the testimony.
Maybe the Myers case.
Yeah. We can find that.
Yes.
Yeah. Any other questions, colleagues? Thank you very much for your arguments. Ms. Patty.
Regarding the speedy of trial question, Justice Walsh, I think my duty of candor requires me to tell you that this is murky. This defendant was serving a sentence in Hutchinson Correctional Facility when the case was filed in early 23 and went back and forth. However, he completed his incarceration portion of his sentence in, I think, November of 24. And then since then, he's been sitting, doing his post release in the Leavenworth County Jail since he got out of prison. So how a speedy trial claim would be decided in this case, I don't know. And as far as, I suppose, in most part, I represent appellants. And I suppose any appellant's going to tell you that every case is important, but some have more possible effect on the entire system, and some are a little bit more narrowed to this specific case. And for this court to exercise jurisdiction in this case and allow, we were harmed, to basically anything that the state gets denied could be a possible interlocutory appeal. And I think that that's dangerous. In giving his ruling, the judge said, the state alleges that these witnesses are crucial, but how crucial were they? The state is now on their fourth time of endorsing witnesses. We do know from the probable cause affidavit that Kalina Burnett told the detective that Mr. Craig came to her apartment after the shooting carrying a bag and she gave him a ride to his girlfriend's house. Doesn't seem real important to me. And in fact, Mr. Zipsigler may not remember, but at the bottom of page 17 and the top of page 18 of his original brief, he acknowledged that there was an insufficient record on appeal to determine whether Ms. Burnett and Ms. Mallory, whether their testimony was critical. So if you do decide to exercise jurisdiction, there could be some splitting of the baby here. Regarding what happened at prelim, the judge said there's clearly conflict. So if you don't call him then, I mean, we could finish this and you could evaluate whether you have a conflict or not. And then Mr. Floyd, yeah. And Mr. Melton, okay, let's do that. I mean, I don't know who really had the burden. Certainly they didn't address this within, say, 30 days. I would also say, you know, when you practice, think about the Rural Justice Initiative. If you practice in a small enough community, you're always going to be running into people that you're currently representing or, you know, have represented in the past. I wish they would have made it within 30 days. In closing, I know I'm again out of time. You know, remember, this is not a case where, like, as I said in the conclusion, where a complaint was filed because someone's sitting in jail and we got to get the process started. They had an opportunity to get all of their ducks in a row. They did not. This was Mr. Melton's case from the beginning. And therefore, Mr. Craig asks you to reverse the Court of Appeals and affirm the district court. If there are no further questions?
Any further questions, colleague? Thank you, Ms. Patty. Court will take this matter under advisement.